Good afternoon, everyone. And I did promise an A-list guest on my Twitter this week, and I have delivered. So I have Dan Herman with me, of course, and Dan is a partner in the injury team at Stewarts and head of the Leeds office. I mean, he doesn't need any introduction, but there it is anyway. And today, I was going to tell you what episode we're on, but I've lost 50 something. You can watch them all online. All the previous episodes are available. I would give you the URL, but people just Google stuff now, don't they? Just Google Stewarts Soundbites and find them and watch them, and they're all available. So today, though, I've got a brilliant topic, and one that's worrying and interesting in equal measure. And Dan's going to talk to us today a little bit about kind of what's going on in the care sector at the moment, the difficulties and kind of the impact on litigation and the evidence and all of that good stuff. But maybe just kind of to kick off, Dan, first of all, hello and welcome. Thank you for joining us. Maybe you just give us kind of a little bit of a kind of quick background to this and tell us kind of what the issues are and how you've seen those kind of unfold in your practice.
Yeah, absolutely. Hi everyone. I think we're all very much aware of what's often been called a crisis in the care sector at the moment, whether you're a claimant solicitor, defendant solicitor, case manager, whether you work for a care agency. We all know how difficult it has been in recent months to recruit and also to retain high quality support workers, rehab assistants, carers, PAs, whatever name we want to put on them. There was a really good report that was tweeted by Babicom recently called the Perfect Storm Survey, and would encourage as many people as possible to read that. I think we're going to add a link to that at the end of today's webinar. Yeah. But broadly speaking, there are a number of factors which appear to have contributed to this current crisis. I mean, first, and in no particular order, Brexit. We all know that a significant proportion of support workers that have been working in the UK in recent years have been people from Eastern Europe, whether it be Poland, Romania, Slovakia. A significant number of those people have gone back home for one reason or other, but Brexit's certainly a factor. A number of care agencies, quite understandably, insisting upon support workers being vaccinated and having their COVID jabs has been a factor. There are, again, is a minority, but a significant minority of people who aren't content with that and don't want to be forced to having their vaccinations. So they're largely outside the pool of available people now. There's been low pay traditionally in the care sector, and contrast that with increased rates of pay in other areas at the moment, which are proving more attractive for some workers. There's also the perception, wrongly I think, of carers or a support worker being an unattractive or sometimes a menial role, when we know that that people who are high quality support workers, that's absolutely not true. Mm-hmm. I think some people have spoke about poor working conditions, and then we can't ignore the fact that there were pre-existing problems that existed before Brexit, before COVID. It wasn't all rosy in the garden in 2017, 2018. There were already difficulties, but those factors that I've mentioned and others, as set out in the Babicom report, have conspired to make the situation even worse than it ever was. Yeah. I mean, just to give one real life example, a case that one of my colleagues, Chris Smith, had, and we had a settlement meeting in December of last year, so only 2 months ago. This is for a high-level tetraplegic client whose care package was running at about £406,000 per year. Fortunately, a week before the settlement meeting, we received a new quote from the care agency, who said that from the 1st of January, the care costs were going to be £471,000, so increase of £65,000 a year, a 16% increase overnight. In care rates, and thankfully we got that information through and could take that into consideration ahead of the settlement meeting. But had we not done our due diligence and gone to the care agency and asked the question, we could have been in a situation where the client discovered this very significant increase in his care rates, having compromised his case, assuming care was going to run at a much lower level. So that's a very real world example of of the problems it can cause in PI litigation.
Yeah, it's a huge jump pretty much overnight, isn't it, Dan, on that case specifically? And as you say, thank goodness for that client. That was kind of discovered beforehand. And I wanted to talk a little bit kind of about expert evidence, because I know that obviously we instruct the experts and what have you, but I think it's fair to say that the claimant and all the team around the claimant kind of contribute to the production of expert evidence in a sense, because we've got, all of the records relating to rehab and what have you. And I wanted to talk a wee bit about expert evidence and how that fits in here, and the importance of expert evidence and kind of documentation and form and expert evidence and all of that kind of stuff in the context of this care crisis.
Yeah. I mean, I'll start off with care expert evidence. Is the obvious one to start with.
Yeah.
And there'll be some nursing care experts, I'm sure, on the webinar today. And we all know, it's trying to say it, but it's worth repeating that, the role of the care expert is to determine, what the individual's care needs are and how those care needs should best be met, and then to cost those, how that care is going to be delivered. And we know there are different approaches. You can have an agency approach, you can have a directly employed approach, you can have a hybrid approach using a sort of a buffer company like Home Care Direct. There are all different options available, and there are certain factors that point towards one option and certain factors that point towards another option. And I think that the care experts need, first of all, to insist before, perhaps not before their visit, but certainly before finalizing their report, insist on having all the evidence. And so that's not just the evidence that they're going to gather from their own examination, assessment of the claimants. It's the evidence that the claimant legal team, the claimant's case manager, the claimant's care agency, and so forth can put the care expert, can give to the care expert. And I do think care experts should insist upon it and say, look, we're not in a normal situation now. Saying, well, an hourly rate of X, add a regional factor to it, that doesn't fly anymore, because we know that you might have an abundance of care in one town, and then 20-25 miles away there might be a real paucity of carers available. So it needs to be at a real micro level, looking at the individual circumstances of this claimant, which is obvious, but also looking at the particular circumstances of that town, that city, that region, and drawing on the experience of people working locally. So the care manager may want to, the care expert may want to speak to local care agencies that aren't involved with the claimant's care. Yeah. The claimant might be having a directly employed model. The care expert may want to speak to that, or to say to the claimant's legal team, look, I need you to speak to these people. I need you to gather evidence from them as to what the local rates are. But I don't think we ever were in a situation where you could just say, look, the rate in the Northeast is X. Yeah. I think it needs to be, kind of hyper localized now to look at the situation on the ground. I also think something I've seen creeping into some care expert evidence, and I think it's a really good idea, is the concept of a loyalty bonus being paid to support workers who stay part of the package. I think there's a temptation to say, well, we'll increase the hourly rate and that will get them to stay. But of course, wages are usually a one-way ratchet. Wages only stay the same or go up. They very rarely go down. It's a difficult conversation to have with a support worker to say, I know you're on £12 an hour now, but we need to go down to 11. Yeah. A bonus is one way of enhancing the overall pay of a support worker without ratcheting up the hourly rate. And if you think about it, better to pay that bonus in certain circumstances to get the support worker to stay, rather than incur the cost of recruiting and training a brand new support worker who is an unknown quantity. You don't know whether they will fit into the care team or not. Yeah. And of course, one of the problems is with the retention, isn't it? It's not only kind of recruitment at the moment; it's also retention as well. So that's an interesting point. And I wanted to talk. I know we talked about care experts there. I wanted to kind of just touch on any other experts you think that this really affects. Yeah. Well, I mean, the most obvious expert is a form of award expert. So some people will know that in most, well, in all, I think, catastrophic injury cases, the claimant should commission a report from a form of award expert to look at whether or not a lump sum is the most suitable form of award, or whether the claimant should opt for periodical payments for certain heads of loss, usually future care and case management. And there have always been a number of positive and negative factors associated with both lump sums and with periodical payments. But the situation we find ourselves in now, with the rate of inflation of carers' earnings, is, in my view, a factor which definitely points towards periodical payments for future care and case management. So just to give a quick law lesson, I won't take too much time Emma doing this, that when a case is when there's an award for a pure lump sum, implicit in that award is an assumption that the claimant's going to be able to make a return on the investment of those damages at roughly 2% ahead of inflation. Yeah. So then once tax, inflation, cost of investment advice, etc., is taken off, the claimant is where they need to be. But it does assume that you can make a return on the investment of your damages at roughly 2% ahead of inflation. Now, if inflation in the care sector is running at 10% plus, 16% in the case I just mentioned before, the claimant hasn't got a hope in hell of getting a return on their investment of 2% ahead of that. Well, certainly not without taking very significant risks. Yeah. I don't think anyone would suggest that claimants who have a lifelong need for care and other losses should be taking significant risks with the lump sum element of their damages. So I think it's another factor towards periodical payments, and certainly the advice that I've been providing to clients that I have with significant care needs is that I think that periodical payments are the route they should be going down, all other factors being equal.
Yeah,
and I suppose commissioning that form of award report and getting it at a relatively early stage, so the claimant can form a view ahead of making any offers, ahead of any settlement meeting, ahead of any trial, is going to be really important.
Yeah, and of course it's relevant that we're far from a settled position on this stuff. It's not like we've reached this kind of peak and that's where we're at now for a while. Things are changing. The requirement for vaccination is affecting things, and that's changing, and there's loads going on. So that's kind of important to take into account as well, I suppose. And I wanted to just touch very briefly on cases where we've of course experienced cases where maybe there hasn't been the opportunity to kind of recruit a care team. Might be that you've got a difficult case on liability, or it settles early, or whatever the circumstances are, but you don't have that kind of established team in place. And I wonder what your kind of view is on how that feeds into this problem, and what we need to be really thinking about in those cases.
Yeah. So it happens quite often, doesn't it, that you've got a case where there's a dispute on liability, and then you might be going to a trial on the issue of liability alone, and ahead of that trial, the defendant will make you an offer for £3 million, let's say, which is less than what the full value of the claim might be, but takes into account the risks that both parties, claimant and defendant, face in potentially winning or losing that trial on liability. And you've got to advise the claimant what is the likely full value of your claim, and therefore what proportion of the full value of the claim does this offer represent. But when you're looking at the full value of the claim, there might be a temptation to say, well, this particular claimant has this particular type of injury. I'm going to look at a care report that we got on another claimant with a similar injury, which will help give me a steer as to what this claimant's care needs might be. It's not going to give you the full position, because obviously every claimant is different, but will give you some sense of what the care need might be. But we can't be placing reliance on those figures, because the way in which care is delivered and the number of hours of care per day that individual claimant might require might not be the same as the previous client, but also the rates that are likely used in those reports are likely to be way out of date now. And so I think in those circumstances, it's incumbent on the claimant solicitor to get in touch with local care agencies, to speak to case managers who operate in that particular region, to ask them what's happening on the ground, what are the rates that are having to be paid in that particular region, to factor those rates in. So even if you haven't commissioned a care report for very good reasons, hard fought case on liability, we still need to be doing that work in the background
Yeah.
to try and determine what the position might be and get a sense of what the actual rates are.
I wanted to talk a wee bit, Dan, because I'm really keen in these episodes to kind of give a little bit of takeaway and some kind of tips for people. And, you know, we'll have case managers watching and rehab professionals and all sorts of different people watching today and that might tune in later. So I wondered whether you could give any kind of advice to those professionals kind of on the ground dealing with these things, and in relation to maybe their documentation or their evidence, or, you know, what are your kind of top tips for those people?
Yeah, well, first thing is I would implore case managers and people in similar fields to document your experiences. You know, don't assume that the claimant solicitor knows what's going on the ground. Don't assume that the care expert necessarily knows what's going on in that particular region. Document your experiences. You know, attendance notes of conversations that you're having with care agencies, interview notes when you are you're interviewing potential candidates for a role, and they talk about their experiences and why they're looking for a certain hourly rate and what other opportunities are out there and what other positions they may have been offered. Documenting what's happening in real life, and then ensuring the claimant solicitors have that documentation, which can then be passed on to the care expert, is absolutely crucial. Exit interviews with carers who are leaving, I think, would be a good idea, so that we don't make any assumptions about why carers have left. You know, is it because of they've been offered a job elsewhere, or is there another factor at play? So documenting those exit interviews would help. And, you know, and if carers are leaving because they say, well, I'm not being paid enough, and you know, I've been offered £2 an hour more somewhere else, then we have that evidence then. And the final thing I would say, and I hope this doesn't come as news to case managers, but it's something I often say to clients and to case managers, is this: most case managers, well, I would say all case managers, should, in the course of litigation, put their signature to a witness statement, whether it's a statement that they produce or whether it's a statement which is produced for them by the claimant solicitors following a meeting, whether on Zoom or face-to-face. So some case managers who have attended trials will know what happens at trial. And this is what happens at trial. The case manager goes into the witness box. The claimant's barrister will say, can you turn to tab 2? Is that your witness statement? Yes. Is that your signature on the final page? Yes. Have you had the chance to read that witness statement recently? Yes. Is it still true to the best of your knowledge and belief? Yes. And that's it. Subject to a few supplementary questions about events that may have occurred post the signing of the statement. That's it.
Yeah. That's
your evidence. So if it's not in your witness statement, the court's not going to hear about it, and the court can't take it into account when making an assessment of what the care needs are likely to be and what the care costs are likely to be. So please do bear that in mind if you're preparing your own statement, or if you're preparing a statement, or a solicitor is preparing a statement from you. Don't assume that you will be able to add to your statement, amplify your statement in the witness box. You may be able to, but there's a very good chance that you won't be able to do that. So witness statements are an incredibly important tool in litigation, providing everyone knows how they work.
Yeah. And as you say, Dan, we've kind of seen, and recently, haven't we, how kind of the minutiae is becoming more and more important. I mean, I've had a case recently where it's just so difficult to find a support worker to work with a brain injured client, and having kind of a documentation of, these are the websites that I've posted on, this is the type of feedback that I've got back from these particular websites, and we've had to enhance that advertising through these different channels and, you know, the associated costs, and that's what we expect. And
one final point, it's right I should point this out. A lot of defendants will say, this is a one-off spike. It's unlikely to happen year on year. Things will calm down. Two things to say about that. First, they're in no better position to know that than claimant solicitors, and I don't know that. Yeah. So it's an assumption, and it's a dangerous assumption, you know, to assume that the inflation on carers' earnings will go back to kind of normal rates after this initial spike. And that's the importance of periodical payments. For those who don't know, when you do get a periodical payment for future care, the increase in the payments every year are linked to carers' earnings rather than an average index, like should the consumer prices indexed. So a periodical payment for future care will step up every year in line with the inflation in carers' earnings, which is why it's much safer in some cases for care to be provided for by way of a periodical payment than in a lump sum. But claimants will make their own minds about that. They'll have their own views on whether they want a lump sum or a periodical payment. It's the role of the claimant solicitor, though, to make sure they have all the information at their fingertips so they can make an informed decision. And part of that decision making will include a form of award report, which has always been essential, but never more so than now.
I find it fascinating. Thank you so much, Dan. And it's given, hopefully it'll give everyone just stuff to think about. And I understand that there'll probably be questions arising from this. And if anyone does want to get in touch with questions or to talk about this in a bit more detail, please contact me or Dan. And thank you, Dan, for all of your wisdom and experiences, which is not a comment on your age, because you are youthful, as we know. But thank you very much, everyone, and take care.
Thank you.